Section 27. Protecting the buyer when the seller is facing foreclosure. Now let's sit on the buyer side of the table. Daniel hangs up the phone after learning that David's trustee sale has been postponed. Marcus and Elena are relieved. Their purchase contract is moving forward, the property is in escrow, and they believe the biggest problem has been solved. Marcus immediately tells Daniel, "Great, now we don't have to worry about the foreclosure anymore." Daniel knows better. The sale was postponed. That does not necessarily mean the underlying default disappeared or that the trustee sale was permanently canceled. David still has a distressed property problem, and Marcus and Elena are purchasing a property while that problem is being resolved. Daniel's responsibility is not to panic his buyers. His responsibility is to make sure they understand the transaction they are actually in. The buyers have money at risk too. Think about what Marcus and Elena may spend before close of escrow. They have earnest money deposited with escrow. They may pay for a home inspection. Depending on their financing arrangement, there may be appraisal-related expenses and other loan costs. They may arrange insurance, schedule movers, provide notice to a landlord, or make plans involving their current home. Some of those costs may not magically come back simply because David ultimately cannot close. Marcus asks Daniel, "If the foreclosure happens, we just get everything back, right?" Be careful. The disposition of earnest money depends on the contract, the facts, and the applicable contractual procedures. Arizona Realtors has specifically addressed situations in which escrow companies face competing earnest money demands and may decline to decide the parties' legal dispute without mutual instructions or a court order. Daniel should explain the contract. He should not guarantee the outcome of a future dispute. The foreclosure is material to the transaction. Suppose Daniel knows the trustee sale was postponed for only a short period and that the new date is dangerously close to the contractual close of escrow. Can Daniel simply say, "That's the seller's problem"? No. AAC R4-28-1101B requires a licensee participating in a transaction to disclose in writing information the licensee possesses that materially or adversely affects the consideration to be paid, including information that the seller is or may be unable to perform, and the existence of liens or encumbrances. A pending foreclosure that threatens the seller's ability to complete the sale is not something an agent should casually ignore. This is why communication between Ashley and Daniel matters. The agents represent different clients, but both need accurate information affecting the transaction. Should the buyers keep spending money? Marcus asks another practical question. Our inspection is tomorrow. Should we spend $550 on an inspection if we don't even know whether David can close? That decision belongs to Marcus and Elena. Daniel can explain the circumstances, the contract, known deadlines, and the risks. He can help them understand that an inspection fee may be paid directly to the inspector and may not be recoverable merely because the transaction later fails. What Daniel should not do is make the decision for them. He also shouldn't say, "Skip the inspection, the foreclosure is more important." One risk does not erase another. If Marcus and Elena proceed with the purchase, property condition still matters. This is something experienced brokers teach constantly. Don't solve one transaction risk by creating a different transaction risk. Title becomes even more important. Daniel also wants Marcus and Elena to pay attention to the title process. David's financial problems may involve liens or encumbrances that must be addressed for the contemplated transaction to close. The title commitment can identify recorded matters affecting the property, but Daniel should not personally issue legal opinions concerning lien validity or priority. If an unexpected lien appears, investigate it through the appropriate professionals. If the title company identifies a requirement that must be satisfied before closing, don't tell the buyer, "I'm sure the seller will take care of it." Verify. In distressed transactions, "I'm sure" is one of the most dangerous phrases an agent can use. What if the trustee sale actually happens? Now imagine the worst case scenario. Despite everyone's efforts, the trustee sale proceeds before David's transaction with Marcus and Elena closes. ARS Section 33-811 addresses the trustee's deed and the legal effect of the trustee's sale. Once that process occurs, the situation can change dramatically. At that point, Daniel should not attempt to give Marcus and Elena an instant legal opinion about their contractual claims against David. That question can involve breach, damages, earnest money, title, and other legal issues. Daniel calls his designated broker. The buyers may need legal counsel. That isn't weakness on Daniel's part. It is knowing where his real estate license ends. And don't forget the contract's cure provisions. Suppose David appears unable to perform by the required contractual deadline. Daniel should not assume the purchase contract automatically disappears. Under Arizona Realtors contract guidance, contractual cure procedures can be critical when a party potentially fails to perform. In the standard contract context, A potential breach generally requires the applicable cure process, and failure to close does not necessarily mean the contract automatically cancels. That is why Daniel needs to read the actual contract and current forms, rather than telling Marcus, the seller missed the date, so we're automatically out. Contract rights come from the contract. Then Marcus makes a decision. After discussing the risks, Marcus and Elena decide to continue. They complete their inspection, remain in communication with their lender, and continue monitoring the transaction. Daniel documents the discussions. Ashley keeps monitoring David's foreclosure status. Michael stays involved. Nobody guarantees that the trustee's sale will remain postponed. Nobody promises that the transaction will close. Instead, they manage the information they actually have. Then another problem develops. David needs additional time to satisfy a lender requirement, but Marcus and Elena's contractual deadline is approaching. Ashley asks Daniel whether the buyers will agree to an extension. Marcus responds, "What happens if we say no?" Now we're back in contract law, and that takes us directly into Section 23, cure notices, extensions, cancellation, and when the deal starts falling apart. Online discussion 1. Marcus asks Daniel to guarantee that his earnest money will automatically be returned if David loses the property at a trustee's sale. How should Daniel respond? Answer: Daniel should explain that the disposition of earnest money depends on the purchase contract, the facts, and applicable contractual procedures. He should not guarantee the outcome of a future dispute. If competing claims arise, escrow may require mutual instructions or legal resolution depending on the circumstances. 2. Why can a pending trustee sale be important information for the buyer, even though the foreclosure belongs to the seller? Answer: the trustee's sale may affect the seller's ability to perform and transfer the property as contemplated by the purchase contract. Arizona's commissioner's rules require written disclosure of information a licensee possesses that materially or adversely affects the transaction, including seller inability to perform and liens or encumbrances. 3. Marcus asks whether he should cancel his inspection because David is facing foreclosure. What should Daniel do? Answer: Daniel should explain the known foreclosure risk, contractual deadlines, and the potential financial consequences of proceeding. But Marcus and Elena should make the decision. Daniel should not eliminate one important due diligence protection simply because another transaction risk exists.